I'm Judge Michael Davis, and this is the First Appearance Court. You're here today because you've been arrested, and under the laws of the state of Florida, you have the right to see a neutral judge within 24 hours of being arrested. Today I'm going to decide two things. The first is whether there was legal probable cause to arrest you, and if there was, I will set a reasonable bond or bail in your case if it's applicable under the law. Now, today is not going to be a trial. There's no jury here. It's just myself, the Public Defender's Office, and the State Attorney's Office, as well as some staff from the jail and from the court. Today is not the day to talk about the facts of your case. I will not be your final judge. I am just here today to handle your first appearance in court. So don't talk about the facts of your case. What we might talk about today are things like your community ties and your ability to post bond. You also have the right to an attorney. The Public Defender's Office will represent you for free for this hearing, and there's a representative there with you in the main jail and one here with me in my courtroom. You also, if you've hired a private attorney already, let me know who they are, and if they're not here, I'll try and call them for you. You also have the right to proceed without an attorney if you'd like. We're going to start today with Caitlin Chapman.
She's in North Broward, Judge.
North Broward, Your Honor.
All right.
Judge, I didn't get a chance to talk to her. I had her listed as main jail, but that's my fault, so.
That's all right. I'm not too concerned with Ms. Chapman's charge, which is possession of cannabis just barely over 20 grams. Mr. Linder, does she have any priors?
No, Your Honor.
All right, ma'am, I'm going to release you on your recognizance on this case. So you're going to go home today, and you'll get a notice in the mail of the next court date and what judge you're assigned to, okay?
Thank you.
All right, good luck to you, ma'am. Take care.
Thanks.
Daniel Diaz.
Yeah. North Broward, Your Honor.
All righty.
Yes, sir.
All right, good afternoon, Mr. Diaz.
Good afternoon, sir.
Oh, did you get a haircut between
Yeah.
when you got arrested? All right. Oh, you look good. Oh, you look good.
Thank you, sir.
Okay.
Thank you.
Okay.
Appreciate it.
You look great. He's got long hair in the booking photo. All right. Well, you're being held on this charge is a misdemeanor warrant for a trespass. That was a municipal ordinance violation, and the bond was set at $100. State, is he being held on the other 5 charges, or is this all that's holding him up?
No, he's in custody on other charges,
All
however,
right.
this case was issued while he was in custody.
Okay, well, so then I can release you on this charge. Will it affect his credit, his game time at all if I do that? Well, so it's really legally your choice. I can cut that $100 bond, but honestly, if I do that, you won't get any credit for the time that you might be serving, and you're already on bond anyway. So, like I said, the choice is yours.
If I may inquire, Judge?
Yeah.
Because we do represent him, I believe, on his felony. Mr. Diaz, are you gonna be able to make a $1,100 bond?
No, no,
Okay,
sir.
all right. If the judge releases you on this, you're not gonna get any credit for time served on it, and you won't be released. Do you understand that?
Yes, sir.
So I'm gonna keep the $100 bond in place. I'm gonna assign an attorney to represent you on this charge. What jurisdiction does this come out of? It's MO48. That'll be Stephen Shate. I see you're from Puerto Rico, sir. I hope that all your family is well and that everybody is safe. And
Thank you, sir.
you will see a division judge soon on this case, on the misdemeanor warrant, and Mr. Shade will also be there with you, okay?
Sure.
All right, best of luck to you. Take care.
All right.
Thank you.
Thank you, sir.
All right. Alan Martin.
Mr. Martin is approaching, Judge, is here at Maine.
All righty. All right, Mr. Martin, you're charged with disorderly intoxication in a public place. I'm going to find probable cause for the offense.
Mr.
Judge,
Martin
before
is
you-
currently being,
Uh-oh. Before you do, it looks like this all happened on his property, right in front of his door, which would not be a public place. And I don't see where anyone else has been disturbed or any other members of the community were affected. Just because he's yelling and screaming doesn't mean that other people are bothered by it or that it's disorderly necessarily. There's nobody else being affected by it.
What were you going to say, Patrice?
I was going to say the defendant is on probation in case 17-9673-MU-10A. His probation began on the 15th of August and continues through the 15th of May next year. Additionally, he's on pretrial supervision, wearing a GPS monitor, which tells me he probably should have been in his house. Case number 176761 CF10A. Burg dwelling with battery, tampering with a witness, victim, or informant, and battery. That is before His Honor Judge Cohen, and he has a hearing scheduled before Judge Cohen tomorrow.
The burglary is before Judge Cohen?
Yes, it's a Burg batch. It's a domestic violence. He
Oh.
went through, had an Arthur here
Oh, I see. Okay, I understand.
Is that one of his conditions?
for pretrial, but typically if he's on DUI probation, I would think.
Well, no, I want to know about the pretrial is that.
I'm 100, maybe 90% certain, but I shall look and see what he
Okay.
signed.
Because even if the court finds no probable cause, Your Honor, there is evidence on the sworn affidavit that Mr. Martin was under the influence of alcohol.
I'll look to see a copy of the pretrial agreement that Mr. Martin signed, and I will tell you if that was one of the things that I see on it. Oh, Mr. Martin.
And here's the kind of confusing thing about the probable cause affidavit, because Mr. Reedy is making a very good point. Christina Martin, who's this gentleman's sister, is the one who signed a victim statement, wishes to prosecute. And the officer says that he met with her. I'm inferring that she resides at the home.
It does list the incident location as her residence.
Right, that's her residence. Christina Jean Martin.
And also in the same probable cause affidavit under his particular address, as far as his home address, it's the same address listed. So according to the probable cause affidavit, both of them live at the home.
They live there, right. All right.
It came from the division, so I don't have, my orders say that specifically. The ones that we write in here, I misspoke. But, this order came from the division, so I do not have that listed on here. I don't have that kind of order. It was just a short order.
Who was
After
the,
his
who was the,
Arthur hearing.
and who was the victim in those cases, do you know?
I'll check to see. The victim was a juvenile and Cynthia Bavata.
So not Gina Matthias.
That's not what's listed here, no, Your Honor.
Okay, well, that's good.
So he came in with no bond and it was a bird back. He went to division and Judge Cohen allowed him to be on pretrial supervision.
With a GPS monitor?
Yes, sir, he had on a GPS monitor. We removed it when he came into custody.
Right. What is your position on Mr. Reedy's argument, Mr. Linder?
No, it doesn't appear to be a public place, Your Honor.
I agree. All right, I'm gonna find no probable cause for disorderly intoxication in a public place. I think that's well argued, Mr. Reedy.
It was all Mr. Romero's idea, Judge.
All right, credit where it's due. And, but the issue is, sir, that you have
Twice a day.
allegedly violated your pretrial release conditions by being under the influence of alcohol, which I have in this sworn to affidavit. Are those also conditions of his probation?
No, it's, I'm looking at the,
Probation,
Pro-
doesn't say.
it didn't, I don't know. I can't say whether the judge ordered it. All I can see on, hold on, let me see. You
I have something here, it says BSO probation, and it says, you will not use intoxicants.
okay.
You will live and remain at liberty without violating the law. Each month you will make a full and truthful report. Not change your residence, work a lawful job, the usual. Attend and complete DUI school, license suspended, immobilization.
Oh, that's right, it was a DUI.
Yeah, and it,
Probation is DUI and the pretrial is
Is the bird
domestic.
bat.
Right, the domestic case, he has a hearing tomorrow morning before Judge Cohen.
All right, I'm gonna revoke the pretrial, and we'll see if Judge Cohen wants to reinstate it tomorrow. What's the case number?
It seems he has a private attorney on that case, Judge.
Oh, is that right? Who's
That is correct. I believe it's Mr. Michael Wallace, Judge. Michael Walsh.
Walsh.
Judge, we didn't hear, what was happening, because I don't know if, we couldn't hear everybody in the courtroom. I believe, the condition you're finding that he violated at this time is that he was intoxicated?
Correct.
Judge, obviously, in reviewing the probable cause affidavit, I don't know if the officer just used conclusory language, just saying the term intoxicated. He didn't indicate anything as far as observing any bloodshot eyes, slurring. What he did observe is that the sister was allegedly saying that he was upset, yelling. I mean, that's what a normal sober person would do if, depending on the circumstances.
Right.
So
The probable cause affidavit indicates it should be noted that the odor of alcohol was emanating from Martin's breath and he was visibly intoxicated. Martin was unsteady on his feet and had slurred speech. So I am going to revoke his pretrial. It's case 17-6761 CF10A. I'm going to set him on a 94806 hold, yes. And what case number is that?
That is,
Different judge or?
17, yeah, this the.
It's gonna be
the
Judge
reading is
Malika.
from Judge Malika, 17-9673 MU10A.
All right, so sir, you're gonna see Judge Cohen tomorrow, and they're gonna set a date for you to see Judge Malika regarding the probation, but I am revoking your pretrial on the domestic case today and holding you for a probation violation. I'm releasing you on your recognizance on the disorderly intoxication charge, as I find there's no probable cause for that. Good luck, and I hope everything works out. All right, Scott Coy.
North Broward, Your Honor.
All righty. All right, good morning, Mr. Coy, or good afternoon, I'm sorry. Sir, you're charged with trespassing private property.
Yes, sir.
I'm gonna find,
Mr.
yes,
Mr. Poi would like to resolve this if possible, Judge.
all right. I'm gonna find probable cause for the offense. Tell me a little about his history, Mr. Linder, if any.
Yes, Judge. His last arrest in Broward was in June of 2016. His criminal history seems to his felony priors pretty much just involve drugs, misdemeanors are loitering, prowling, trespasses in general.
Sir, are you gonna be able to stay away from the mobile gas station on Sunrise Boulevard?
Absolutely, Your Honor.
1565? All right, that's gonna be,
Absolutely.
that's gonna be a condition of the plea. I'll allow you to plead no contest, and I'll withhold adjudication. You'll just have to pay some court costs, but you have to stay away from the mobile gas station. That's the one on 1565 West Sunrise, okay?
Yes, sir, Your Honor.
All right, sounds good. Go ahead and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead and put your hand down. Tell me your full name.
Scott Aaron Coy, K-O-I.
All right, Mr. Coy, you've been charged with a trespass. Do you wish to plead no contest to that offense?
I do, Your Honor.
All right. Do you understand by pleading no contest, you're giving up your right to a trial?
I do, Your Honor.
Are you under the influence of any drugs, alcohol, or prescription medication that would make it difficult for you to understand what I'm saying today?
No, sir.
All right, I'm going to find your plea to be knowing, intelligent, and voluntary. I'll withhold adjudication, and you'll have a year to pay those court costs, okay?
Yes, sir. What's my sentence?
There's no sentence. You're going to get out today. I didn't even find you guilty. I just withheld adjudication, but don't forget, Scott,
I can't go to the mobile gas
can't go. That's the
station.
most, if you forget everything else, do not forget that, okay?
Yes, sir. Thank you, Your Honor. Have a good day.
All right, good luck to you. Dijon Frazier.
Mr. Frazier is here, present and main judge. He advised me that his friend is gonna be posting his bond.
All right,
Your Honor, does the court find probable cause? It should.
Yes, I'll find probable cause for the cocaine possession, possession of cannabis.
I would take
resisting
issue with that.
officer, and trespassing. Which one, the cannabis? or
All of
the-
it.
All of it,
First of
okay.
all, we have no idea how this officer knew that this car was stolen, which justifies his entire stop of Mr. Frazier. There's nothing in here that he checked anywhere to find that it was stolen, other than maybe Mr. Frazier's appearance might have been the only reason that the officer stopped him. But let's assume that if the car is not registered to Mr. Frazier, this description that something was located in the driver's compartment, we don't even know what that means. We're talking about 0.5 grams of cannabis and 0.25 grams of cocaine, very small amounts. They could have been anywhere inside that driver's compartment. If it's not his car, I don't think this court can find probable cause based on the assumption that he knew it was there. So I don't think there's probable cause for possession of cocaine because we don't know where it was. We don't have probable cause for the possession of marijuana because we don't know where it was in the vehicle. And what concerns me about the credibility of this officer's report is that he comes out with this claim that the vehicle is stolen and he has nothing to back it up. So I'm curious as to why Mr. Frazier was detained in the first place, perhaps grounds for a good motion to suppress down the road. And once again, these small amounts of drugs found somewhere in the driver's compartment. I don't even know what driver's compartment means. Under the seat? Taped up underneath the steering wheel? I don't understand what that means. And I don't think that the court can find probable cause without some clearer description of the location of these substances.
Your Honor, the court can absolutely find probable cause. Mr. Reedy is raising the standard, Your Honor, and he mentions motion to suppress. That's exactly where that argument, as far as the initial stop, is relevant at a motion to suppress, not at a first appearance. As far as it's if it didn't mention where Mr. Frazier was sitting in the vehicle, then I can understand how there could be an issue. But considering it mentions he was the driver of the vehicle, and it mentions compartment, the driver compartment, indicating a compartment where the driver is. That's just plain reading of the language, Your Honor. Now, I agree, it doesn't mention specifically what compartment, but a compartment of the driver area. Since he was operating the vehicle, in control of the vehicle, Your Honor, there is probable cause that drugs found in the driver's area, in a compartment, that he would either would have a constructive possession of those drugs, Your Honor.
Mr. Frazier, I don't think was ever seen driving the vehicle.
It does
He's
mention
seen getting out of the
exited the
driver's
driver's
side.
seat of the vehicle.
Well, that's not the same as driving the vehicle, and there were 3 other people inside.
So the passenger was driving the vehicle while Mr. Frazier was in the driver's seat?
Maybe no one was driving the vehicle. It's not his car. How's he supposed to know what's inside? If I came into court earlier today, Judge, and taped something underneath Mr. Lender's chair, and then later it was discovered, and Mr. Lender would say, hey, I didn't know what it was. I didn't know it was there. But it's within the lender control, the lender compartment of the courtroom, so it would be attributable to him, and according to Mr. Lender's argument, then he would be responsible for whatever it was. We don't, this is just a poorly written probable cause affidavit that doesn't give the court enough detail, enough information to make a determination of probable cause.
Again, Your Honor, that is not a valid example, considering that a vehicle is a movable object, where certainly, Your Honor, it is a reasonable conclusion. The car got there somehow. It didn't fall out of the sky. Mr.
There's an
Frazier,
assumption.
excuse me, Mr. Frazier is the one exiting the driver's seat. This table doesn't move, doesn't go anywhere. Multiple people could come here and sit. He was
Multiple people could have been sitting in the car. Oh, I'm sorry, I thought you were done. I thought you
I
were
did not
done.
interrupt you.
I
Even
thought-
one,
I
even
thought
one
you were
time.
done, Eric.
Even
I'm sorry.
one time. Please, just let me finish. Then you can go on in a loud voice and talk about,
No
Your
loud
Honor,
voice.
excuse me,
All right,
please.
gentlemen, you could both say whatever you would like to say about the case, but let's not have the back and forth. But I'm gonna let you both talk about the case and your arguments as long as you would like, but let's just go one at a time.
Yes, Your Honor, and arguing that probable cause is the lowest standard, is there a probability? He's seen exiting the driver's seat. Drugs are found in the driver's area of the vehicle. Certainly, the officer has probable cause to believe that Mr. Frazier's to charge him with the possession of the drugs found in the driver's area.
I just don't think there's enough detail here, Judge, for this court to make a determination that this was there's no indication it was in plain view. Certainly if it was in plain view, I think that's something the officer would have written in his report. In plain view, I saw this. So let's assume, based because he didn't say that it's not in plain view. It's not Mr. Frazier's car. Mr. Frazier's never seen driving the car. There's 3 other people in the car. All we have is Mr. Frazier getting out of the driver's side door and small amounts of narcotics being located somewhere in the driver's compartment, which for all we know includes the center console. We don't know because it's a poorly written report.
And I apologize, Your Honor, to be remiss. One other thing I meant to mention. Additionally, the allegations that Mr. Frazier pulled away from the officers and attempted to run away indicates a consciousness of guilt.
I think that's preposterous. I think that almost anybody might want to run away from the police these days. Certainly the fact that he pulled away or did anything like that has absolutely nothing to do with it.
So,
There's no conscious evidence of guilt,
and
especially based on what I think we're about to hear.
all I was going to say is Mr. Reedy might want to try to turn this into a political thing, but Your Honor, there's not a legal justification for everybody to just run away from the police nowadays.
Everybody said what they had to say, everybody happy
Nothing
with
further
their
from the
arguments?
state.
I'm done.
All right, very well. All right, I am going to find probable cause for all counts, sir. What did you want to tell me, Mr. Linder?
Your Honor, Mr. Frazier was arrested August 2nd of this year, was released on September 16th. He's out on bond on 1 count of burglary of an occupied dwelling, 1 count of burglary of a conveyance. He's out on ROR for grand theft auto, resisting without violence, tampering with evidence, and driving with a suspended license, 3rd or subsequent offense.
Is that all one case, or you said there's 2
I
cases?
think it's 2 separate cases. I can check to make sure.
All right, Mr. Romero?
Judge, Mr. Frazier lives in Fort Lauderdale with his mother. He tells me he really wants to try and see if he can post bond. Judge, I'd ask you at this time to not consider revoking Mr. Frazier's release on the 2 outstanding cases. I'd ask you to take into account Mr. Reedy, my colleague's argument as far as the strength or weakness and as far as our position goes, as far as this case goes. I don't even know if this case is going to be filed. Judge, I'd ask you at this time to consider leaving the standard bond in place as far as the new law offense. And I ask you if the court does have any concerns, to at this time maybe consider a stricter form of pretrial. Therefore, the court would have additional safeguards or assurances that Mr. Frazier would be abiding by any court orders that you feel at this time are appropriate. But I'd ask you at this time not to revoke his release on the cases that he's out on.
And Your Honor, the only thing I would ask, if the court is not inclined to sua sponte revoke Mr. Frazier's bond and release, then I'd ask the court to consider bond increases on these charges. In addition to his pending cases, his criminal history, he was convicted in May of this year for possession of PVP. Last year, he was convicted of possession of PVP, was sentenced to 120 days county jail. 2015 grand theft auto, he violated his probation, 180 days county jail. 2014, he was convicted of violating pretrial release conditions, that being a no contact order. That stemmed from a battery in 2013 that he was convicted of. He actually was convicted twice in 2014 for violating the release conditions no contact order from the battery case. 2010, possession of cocaine with intent to sell or distribute with a VOP. 09, delivery of a counterfeit controlled substance with a VOP. 08, delivery of a counterfeit controlled substance with a VOP. 2008, delivery of cocaine with a violation of probation.
Judge, one additional piece of information. If Mr. Lender's finished, I don't want to interrupt him.
He has no other criminal history.
Thank you, Mr. Lund. Judge, one other reason I'd ask you not to revoke his release is he is a father of 2 children, ages 3 and 4. Right now, him and his children are living with his grandmother at his grandmother's house in Fort Lauderdale. His grandmother does collect Social Security, and he also works. He works in construction, so he gets paid daily. He contributes to the financial income of the family. That's why he really wants to be out there, and he doesn't. We wouldn't object if the court wants to put additional safeguards in place as far as a stricter form of supervision or anything like that. We just ask you at this time to once again consider my colleague's argument as far as the weakness of the case and allow Mr. Frazier to potentially bond out.
All right. Let's do a $7,500 bond on count one, pretrial release, level one, house arrest, GPS monitor to be affixed with a house arrest. All right. Good luck to you, sir. Tion, and that doesn't preclude the state from seeking to have your bond revoked in the other cases, sir. I don't know what the state's going to do. All right. I'm just saying I don't know what the state's going to do. They may still seek to have your bond revoked on the other cases. That's going to be up to the state attorney's office. All right. Good luck.
Your Honor, our Spanish interpreter is here.
Yes, I saw that. Hello, Teddy. How are you?
Excellent. How are you today?
Great, great. Who needed the Spanish interpreter? Which case?
It's here at Maine. Senor, ¿qué es tu apellido? Mr. Barbon, Judge.
Mr.
He is
Barbon.
on page 8 of your docket.
Thank
you.
Uh,
Great.
2 from the end of your packets, I'm assuming.
Great. Theodore, if you could just raise your right hand. Do you swear or affirm to accurately translate from English to Spanish and Spanish to English to the best of your ability?
Yes, I do, Your Honor. Theodore Leal, Leal for the record.
All right, thank you. All right, sir, I'm Judge Davis.
Señor Juez Davis,
You're charged with grand theft auto,
se le acusa de auto de mayor cuantía, de delito de la ofensa de robo de auto,
failing to wear a seatbelt,
no tener el cinturón de seguridad puesto
and operating without a tag light.
y estar manejando sin tener una de las luces.
I'm going to find probable cause for the offenses.
Voy a hallar que sí hay motivos fundados por este cargo.
Does Mr. Barbon have any prior state attorney?
Does pretrial have anything else?
Van a ver si tiene antecedentes.
I know, but I don't. He might have said, I don't know if he has anything out of Broward.
Okay.
No tiene antecedentes.
All right. I'll release you on this charge, sir.
Sí, entonces lo vamos a poner en libertad por este cargo.
They're going to be sending you a notice in the mail when to come back to court.
Le van a enviar la notificación por correo de cuándo volver al tribunal.
If you miss that court date, sir,
Si usted falta y no comparece a esa fecha a la corte,
our warrant will be issued for your arrest.
se emitiría entonces una orden de arresto.
Do you understand?
¿Entiende? I understand.
All right. Good luck to you, sir. Take care of yourself.
Suerte para usted, señor, y cuídese.
Anyone else for the Spanish interpreter while we have him here?
¿Alguien más?
Here at Maine, Judge.
No mas. All right. Thank you, Teddy. Great
Very
to
welcome.
see you. Have a great day. Tion Watkins.
North Broward.
Okay.
Yeah, I got it.
All right. Good afternoon, Mr. Watkins.
It's supposed to, but he didn't even mention the bullet.
All right. Mr. Linder, is this a booking error or are they just charging him like per bullet?
No, you know, I believe that was the officer's intent per bullet.
But he doesn't say how many bullets there were.
That's what I was gonna say. So, I mean, frankly, even if he did, normally the custom is to ROR and the counts for bullets. So I have no objection to no PC on 3 through 12, and I'm not gonna ask for any time because normally they would have been ROR'd anyways.
Yes, okay. So I'm gonna find no probable cause on counts 3 to 12 and release you on your recognizance on those charges, sir. There's no legal probable cause. Now, you're charged with the following. You're charged with the following: commission of a third-degree felony with a weapon, possession of a weapon or ammunition by a convicted felon, possession of cannabis over 20 grams, possession of cocaine, driving with a suspended license without knowledge, and failure to wear a seatbelt, and possession of an open container in a motor vehicle. On those counts, I will find that there is probable cause. And what is Mr. Watkins' criminal history?
2010, possession of cocaine with intent to sell or distribute. He was convicted of that charge. Possession of marijuana and resisting without violence. In 2008, battery on a law enforcement officer. He received a withhold on that. Resisting without violence, possession of cannabis.
All right, Mr. Reading?
I'm just looking at the statute that the officer cites in the probable cause.
And Your Honor,
affidavit.
and I apologize, count one should be no PC as well.
Oh,
Oh, okay, all right,
okay.
all right. Then I don't have any further argument as far as count one is
I'll
concerned.
release him on that charge as well, no probable cause. Sir,
Your Honor, he's been living here all of his life. He has extensive family here, including his mother and his wife.
okay.
He's given me his wife's phone number. I intend to call her to let her know what the bond situation is. He has some college education. He's a graduate of Boyd Anderson High School, class of 2005.
Okay.
He lives with his wife. He indicated to me that he has not failed to appear in court on any prior occasions, although he has been in some trouble in the past. I'd ask the court to set a bond that his family can afford. It's probably somewhere in the area, maybe of under $5,000.
Yeah, I'm gonna do that. We'll make it $1,000 on count 2, and then it's 1,000 on 13 and 14. There's no monetary charge on the other counts, so it's a $3,000 bond total, sir. All right, good luck to you.
All right, thank you.
All right, you're welcome. Jonathan Rosa? All right, good afternoon, sir. You're charged with possession of heroin and possession of cannabis. I'm gonna find probable cause for those counts. What are his priors?
He has a pending possession of heroin with intent to sell or distribute. Also felony possession of marijuana 2012 with the VOP.
Is that already filed? I'm sorry to interrupt you.
It has been filed.
Been filed?
2007, possession of cocaine, a year in a day state prison. 2001, burglary of a dwelling and grand theft. He violated probation, 6 years Florida State Prison.
Patrice, was he interviewed?
Yes, Your Honor, he's on her recommendation on the fact that he does have that pending case, in front of Judge Bailey for that seal.
Tim or Dennis?
I have to check all of the work here with Bailey.
No, that's okay, you don't have to. I don't know, you might be a good candidate for the drug court if that was something that you were interested in.
The issue might be, Your Honor, that based on his pending case, the only issue might not be using,
Right.
but dealing.
Right.
And it's,
He has a prior adjudication, even though it was many years ago, they treated him as an adult in that case, and so that adjudication would preclude him from the regular drug court, maybe post adjudicatory, but
Oh, that's too bad. All right, Mr.
history of failure to appear and stuff.
All right, Mr. Romero?
Judge, he informed me, he could self-bond. So we'd ask you to leave the standard bond in place.
All right. Sir, I'm afraid, given the nature of this charge and the charge that that is pending, I'm going to revoke your pretrial release conditions, your bond in that case, if I could have the case number, and you'll have to go see Judge Bailey.
174769 CF10A.
All right, you're going to have to see Judge Bailey. They're both very good judges. And
It's Tim Bailey.
It's Tim, okay. And they'll make a decision going forward. Even if you're not in the drug court, there are drug programs available, and Judge Bailey will know of them. That might be the way to go for you. I guess we'll see. And it'll be a $1,000 bond on count 1, no monetary charge count 2. Good luck to you, sir. You take care. If you want to do the SAP program while you're in, I can order that. No?
No, thank you, Judge.
Okay, all right. Oops, sorry about that. Can you reach that? Lazaro Hernandez Rodriguez.
I've been informed he bonded, Judge.
All right, let's find probable cause. Randall Gordon.
It's still a medical.
Probably going to be
reset.
a medical loan for a little while, I would imagine. Okay, so med reset. Joseph Sanchez.
Your President, main judge.
All right, Mr. Sanchez, you're charged with possession of Xanax, possession of a controlled substance without a prescription. You're also being held by a court order of Judge Usan, which I have here. Judge Usan ordered on the 26th, which was yesterday, that your bond was revoked and you're remanded to custody on the charge of an armed carjacking. So I'll find probable cause. Counts 1 and 2 will be $1,000 each. You're going to have to see Judge Usan about the carjacking charge, and I'm assuming that they'll set up a date for you to see him soon. All right, good luck to you, sir. All right, do you happen to have that second look docket for me? Thank you so much. Oh, thank you. Wonderful, you're the best. All right, anybody left there at the main jail?
Yes, Judge, we have one gentleman here on the 30-day ROR motion. His name is Herman Williams.
Herman Williams, okay, Mr. Williams. All right, great. And we're gonna see if the charges were filed, sir.
Charges were filed.
Charges were filed, okay, so the motion for release on recognizance is gonna be denied, because the state has filed their charges, but you'll see your division judge very soon. All right, good luck to you. Didn't I reset that gentleman for this afternoon, the one who was at the Hard Rock, remember? I don't see his name.
Yeah, I don't see his name on the docket either. I know that Mr. Michelson from our office,
Yeah, because you were here, yeah. Mr. Michelson went out to visit
he
him?
did visit him. The gentleman indicated to Mr. Michelson that he was going to try and get his roommate to bond him out.
Oh, maybe.
So maybe he bonded. I don't remember his name offhand.
He didn't mind.
She has the paperwork, so.
All right, because I was thinking about him. I mean, I was thinking about the case,
I
so,
brought, he didn't show up on the document,
yeah.
but I brought the file just in
All right, I'm
case.
glad you brought it. Maybe we can get him up. He was in North Broward, right? I think he was. Thank you, Mr. Romero. I'll see you tomorrow. All right, where is?
Tomorrow, Judge.
All right, very good. Let me go to North Broward. North Broward, do you guys have anyone there for 30 days for a second look?
I don't know if they're for the second look. I got two guys here. I got Robinson and Calaman.
All right, let's bring up Robinson first. Yeah, do you think you could see where that gentleman is, where his housing is, Sheila?
What's that?
Oh, no, yeah, Sheila will have it. Hi, Mr. Robinson, you're here for a motion for release on recognizance. Have those charges been filed?
I'm sorry, who is this, Your Honor?
This is Courtney Robinson. Right, that's your name, sir, Courtney Robinson?
Yes, sir.
All right, very good.
He's entitled to an ROR on these charges, Your Honor.
Okay, all right, so, sir, the charges have not yet been filed, so you're gonna be released on your recognizance on this case only. It doesn't mean it's going away necessarily. The state might file charges still, so keep an eye out. They might send you some information, okay?
Okay, appreciate it, sir.
All right, you got it. Good luck to you. And then, Deputy, you said you had one more? Oh, hi, sir. What's your name?
My name is Myron Coleman Mines.
Meyer Holloman. Oh, okay, I see you here, sir. All right, you're here for a motion for release on recognizance.
Charge has been filed.
All right, so that charge has been filed, so the motion for release is denied, and you will see your division judge very soon to talk about the case.
So can I ask one more question, please?
Yes, of course.
When has that charge been filed? Because I talked to my public defender, and for the grand theft, he said the charges haven't been filed, and for the petty theft, I had them charges resolved. I resolved that charge.
The question is, when did he speak to his public defender?
I speak to my public defender on Monday, and he told me that my charges haven't been filed.
It's filed
And
today.
All right, they filed it today. They filed the charge today, so he was right on Monday, but he was not right as of today.
All right, so can I have one more question.
Sure.
And he said if they did file the charges, he was going to ask, can they reinstate my bond?
He's going to have to ask that of your, and that's a good question. I mean, that's a good idea. It's a wise strategy. He's going to have to ask that of your division judge, who is Judge Bailey. All right, he's going to have to ask it of Judge Bailey.
So do you have a date when I'm going to see Tim Bailey again?
I do not know if there's anything that's been
There's
set up.
nothing in Odyssey.
Yeah. But I would contact your PD immediately and let him or her know that the charge was in fact filed, and to ask her to please set up a date with Judge Bailey.
You need to call Kristen Taylor, sir.
All right.
Kristen Taylor is going to be your public defender.
Do you know Kristen?
Yeah, that's why I talked to one public defender on Monday, then I talked to Kristen Taylor on Tuesday.
Probably spoke to an
And she
ERU.
And they said my I don't know if y'all want to look at it again, because they said my charges wasn't filed.
Yeah, no, they filed the charge today, sir. So that's why it didn't show up. They weren't wrong when they spoke to you. It's just that they have 30 days to file it, and they filed it today. That's the 30th day. All right.
So because I've been locked up for about 40 days, and they just now following it.
Yeah. All right. But talk to Kristen, okay? Give her a call. all right?
Yes, sir.
Good luck to
All
you,
right.
sir. You take care of yourself.
Okay.
Did we find out where that gentleman is?
Yeah, North Broward just called about him.
They did.
Yeah.
They're gonna bring him up?
They don't know who it is either.
Oh, he's at Conti.
Oh, he's at Conti, okay.
There you go, okay, all right. All done at North Broward? All right, let me go over to Conti then. All right, great, thank you.
Thank you, Your Honor.
All right, sure. Hi, good afternoon, Deputy. We're gonna have a gentleman brought up, we're gonna have a gentleman brought up today, unless, Brian, I don't know if when the PD spoke to him, he said, well, I'm just gonna bond.
Well, he thought he was gonna be able to bond, but if not, I think we should bring him back to see what it is that he wants to do,
I
because.
just hope that PD gave him some advice on that specific issue. that
Well,
we
I
were talking
talked with
about,
Mr. Michelson and advised him
All right,
what
good.
the issues were, so he
right.
should have.
So, do one of you mind calling over to Conti and just giving him the BCCN, all the information? All right. In the meantime, sir, at the podium, what's your name?
Hunter Martin.
Hunter Martin. Okay, very good. We're here for motion for release and recognizance.
He's entitled to an ROR.
Sir, the charges in your case have not yet been filed, so you're going to be released on your recognizance on this case only. Doesn't mean it's going away. The state attorney might still file the charges, but today you'll be released, okay?
Thank you, sir.
All right, good luck to you, sir. Come on up, sir.
Judge, what was his name?
I don't remember.
No, the one you just did.
Oh, that was Hunter, all right. Sir, what's your name?
Lorenzo Epps.
Epps, Mr. Epps, Lorenzo Epps?
He's entitled to an ROR.
All right, sir, the charges in your case have not yet been filed, so you're entitled to be released on your own recognizance.
Very loud.
And, no, I'm so sorry, and just to make sure that you know, the state may still file charges, so keep an eye out in the mail. They might send you some information, okay?
Good day, Your Honor.
All right, good day.
Usually Sanchez is over there, but I just looked at it now.
Thank you. All right, sir, what's your name?
Antonio Telfair.
Antonio Telfair. All right, very good. We're here for a motion for release. Those charges been filed? Patricia giving you a problem?
He's entitled to an ROR.
All right. All right, Mr. Telfair, the charges in your case have not yet been filed, and you're going to be entitled to be released on your recognizance. The state may still file charges in the case, so keep an eye out in the mail if they send you the information, okay?
Judge, he still has a
All
no
right,
bond
thank you,
hold.
sir.
Oh, you're not going to be let out of jail because you do have a no bond hold on another case, but on this case, 17-9351 CF10A, you are released. All right? Good luck.
Thank you, sir.
Good luck. You take care. Hi, sir. What's your name?
Kevin Semenos.
Oh, okay. You're here for a second look. This is a municipal ordinance case. You were charged with possession of an open container. How long has he been in? The 23rd of August. I guess something else was holding him? Really? Why didn't he go to division? All right, well, sir, I'm going to offer you a withhold of adjudication, and you'll have a year to pay some court costs. You want to do that?
Yes, sir.
All right, go ahead and raise your right hand. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, go ahead and put your hand down, and just tell me your full name, Kevin.
Kevin Curtis Semenos.
All right, Mr. Semenis, you've been charged with possession of an open container of alcohol. Do you wish to plead no contest to that offense?
Yes, sir.
All right, do you understand that by pleading no contest, you are giving up your right to have a trial?
Yep.
Are you under the influence of any drugs, alcohol, prescriptions that would make it difficult for you to understand me today?
No, sir.
All right. I'm going to find your plea to be knowing, intelligent, and voluntary. I'll withhold adjudication. You'll have a year to pay some court costs. You'll be released today, okay?
Appreciate it. Thank
All
you
right.
so much.
Good luck to you. Take care of yourself. All right. Anyone else there at Conti?
No, Your Honor, the name of the inmate we're looking for?
Oh, yes. What's his name? Elrod.
Yes, I called Bravo 6, he's supposed to be brought.
All right. So they're going to bring him up.
He's on his way now.
That's great. I'll come back to you in a moment. I'm just going to go over to Ryan.
Okay.
All right. All right. Good afternoon, everyone at Paul Ryan. Let's see here. How about Tramail Kelly? Hi, Mr. Kelly. All right.
How you doing, Your Honor?
I'm doing well. You're here today for a motion for release.
Mr. Kelly can be ROR'd at this
All
time.
right, sir. You're going to be released on your own recognizance. The state hasn't filed the charges yet. They might file them in the future, so keep an eye out for some information in the mail, okay?
All right.
All right, good luck to you. You'll be released today, sir. All right. How about Jathwan McNeil? All right, good afternoon, sir. You're also here for a motion for release on
This is a
recognizance.
second look.
Oh, this is a second look. Okay, I'm sorry. I'm failing a second look.
Yes.
All right, give me 1 second, and I'll take a second look. Okay, let's see. Mr. McNeil. All right, you're charged with grand theft auto.
What is your name? Elrod?
I'm going to take a look at your case now, sir. What's his bond, 1,000?
Yes.
Do you have any significant priors?
I'm checking that right now.
No, no, this is my first time being arrested.
Well, we're looking for juveniles. He's 19. You don't have any juveniles?
No.
Nothing, Eric?
Pre-trial's telling me he's got nothing.
All right, Jathan, I'm going to release you on your recognizance on this charge, so you're going to get out of jail today, and you will. But the case is not going away, so you've got to keep an eye out in the mail. They're going to send you a notice to appear. Okay, if you miss that, they're going to send out a warrant for you. Okay.
Okay, thank you.
All right. Good luck to you. How about James Warren?
It's a second
All right.
look.
Hi, James. All right, so this is also a second look. All right, trespassing an occupied structure, tampering with evidence, and a county ordinance violation. Let me see here. What's he been in, like 8 days? 7 days?
He was about 12, 11.
What are his priors?
As far as Broward goes, 2013 tampering, 2010 marijuana, 2010 tampering, 2008 resisting without, 07 cocaine, 99 cocaine battery, 98 delivery of cocaine.
All right. Oh, the tampering is a felony charge.
Yes.
I was gonna work it out for him today. Let me see. You got a stable address where they can send you a notice in the mail to appear?
Yes, Your Honor.
All right. I'm gonna release you on your recognizance on all
Okay,
counts.
Your Honor, I've just asked if we can inquire what the address is. Looking on the report, I mean, it was listed as none, or at least on the booking.
All right, what's the address? Where do you want them to send the mail?
33 Southwest 8th Avenue, Dania, Florida, 33004.
Who lives there? Is that a
My
relative?
grandmother.
Grandma?
My grandmother, yes,
All
sir.
right. And you understand it's your responsibility to go to grandma's house to pick up the mail? Or
Yes, sir.
or you can check online when your court date is. Were you able to get that address, or do you want me to say it again? So just say it for me one more time, Warren. I'm James.
33 Southwest 8th Avenue, Dania, Florida, 33004.
Okay. So that is the address that they're gonna send the court notice to. If you miss court, like I told the other gentleman, there's gonna be a warrant out for your arrest, okay?
I understand.
All right, now, honestly, I think 12 days, I would have worked it out for you. The problem is it's a felony charge. That has to go up to the felony court. We'll see what the judge does, but you must come back to court, okay?
Okay.
All right, good luck to you, sir. You take care of yourself. Did I miss anyone over there at Paul Ron?
No, sir, that's it, sir.
All right, have a blessed day. Well, it's actually, so it was a second look. It wasn't a ROR motion. You might have to do a different order. I am RORing him. It's the same one? Okay, yeah, so I am RORing him, but, all right, now let me go back to Conti. All right, hi,
Elrod, Kenneth Elrod.
that's great. Hi, Mr. Elrod, how are you doing?
I'm pretty good, Your Honor.
Good, all right. So I know that Mr. McDaniel came and spoke to you from the Public Defender's Office. Mr. Reedy was telling me that you thought maybe you could bond out, but it looks like that didn't work out.
It hasn't yet, Your Honor.
All right. Did he give you any other legal advice about the other things we were talking about, the civil commitment and?
Yes, I'm going back to Iowa.
All right. So do you want to? Was Mr. McDaniel comfortable with you taking a no contest plea today? Did he feel that? Oh, I'm sorry. Mr. Michelson. I apologize. Was Mr. Michelson comfortable with you taking a no contest plea to the charge and then heading back home?
Yeah, he seemed to be, yes, sir.
I would agree, Judge.
All right, and I actually spoke to Judge Brown about it today as well, as I saw her, and, you know, she seemed to feel that was a good course of action. Again, we can't tell you for a certainty. No one can really tell you for certainty. What I can tell you for a certainty is this, though, and I'm saying this to scare you just a little bit. I can tell you for almost a certainty that if you do not leave the state of Florida, you will likely be arrested for the felony charge of failing to register. That's just advice that I'm giving you. So I do hope that you go back to Iowa. I hope that you make your peace with your sister, and I pray for her and her health. So what we'll do today is, if you want to plead no contest, I'll withhold adjudication, and you'll have to pay some court costs within a year. They'll give you information on that, and then the case will be all done. Okay, you want to do that?
Yes, sir.
All right. Go ahead and raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir, I do.
All right. Go ahead and put your hand down and just tell me your full name.
Kenneth C. Elrod
All right.
Jr.
All right, Mr. Elrod, you've been charged with what was it? It was a trespass. Trespass. That's
The
right.
Hard Rock
At the Hard
Cafe.
Rock. I remember there. I just couldn't remember if it was an open container or a trespass. So you've been charged with a trespass. Do you want to plead no contest to that charge?
Yes, sir.
Do you understand that by pleading no contest, you're giving up your right to have a trial?
Yes, sir.
Are you under the influence today of any drugs, alcohol, or prescription medication that would make it hard for you to understand me?
No, sir.
All right. I'm going to find your plea to be knowing, intelligent, and voluntary. I'll withhold adjudication. You'll have some court costs to pay. You'll have a whole year to pay those, and they'll give you the information about that. And I hope you have a safe trip back to Iowa, sir.
Thank you very much.
All right. You take care. All right.
Thank you, sir.
Thank you. Thank you, everyone. Good job, and I will see you all tomorrow. Oh, no, bro.